Hi everybody, this is Arkady Frekhtman, a New York City personal injury trial attorney, and today we are here with Last Week Tonight, where we answer your questions. It's all about the viewer. It's all about you. We read your comments and questions and we answer them. So let's go to the first question. We're still about 2 weeks behind. Hopefully we can go quickly and catch up today because it's the holidays coming up. It's the late December. It's a Friday. Today is December 16th, and I'm trying to catch up. And brutal honesty, I love doing this. I love helping people, so let's do it. So the first question is from T-Mac, and he's from Reno, Nevada. And he or she asks, slip and fall on ice in an apartment complex parking lot, had a tib, fibula, or if that's open reduction, internal fixation in the ankle, and also a STEMI, myocardial infarction. Ooh, that's pretty serious. What is my case worth? Now, I'm not really familiar with Nevada values. I do know a lot of excellent trial lawyers in Nevada, so if you needed a consultation, I'm happy to help you. Just text me, 347-566-9595. I know some of the best. This one lawyer in Nevada actually recently, I was chatting with him at one of these conferences, and he recently won a jury verdict, I think like $17 million. He's a really good lawyer. So I could discuss that, with him. Maybe he can give you a consult. I think he's a very nice guy, and he's, willing to give a consult if somebody has a serious case like this. But this case, look, if it happened in New York, based on my knowledge, slip and fall, if it's good liability, meaning they had ice and they should not have had ice, they should have cleaned the ice, as long as it's not like snowing, there's no precipitation, right? They had time, like the precipitation stopped, and then they had time to clean the ice, and they didn't do it, right? And then you slip and fall on the ice, it's their fault. If you have liability with that kind of injury, with an open reduction internal fixation, with a tibula-fibula fracture, plus this myocardial infarction, as long as the doctor says that the myocardial issue was caused by the slip and fall. You have to have that causation, that medical causation. So as long as you have that, just the open reduction internal fixation, that's such a serious injury. I think just that alone is probably worth close to $1 million. It might be a little less, like they might offer you, 500, 600,000. But if it's worked up the right way, it could also be more, right? Remember all of the different things. You have the pain and suffering, you have the loss of enjoyment of life, you have the medical expenses. In the future, with an open reduction internal fixation like that, sometimes you have to have a revision surgery in the future, either to remove hardware or just because of issues. Like some people develop arthritis because of that. Like I don't know the age of this person. So just generally, I think it's a serious case. It's either high 6 figures or low 7 figures. It's a serious case. It's a great case. I couldn't really tell you exactly. So if you wanted to know exactly, just text me and I'm happy to talk to you about it. Okay, and then Ray E says, I love the questions videos. Okay, thank you, Ray. Yeah, Ray is one of our, one of our frequent contributors. So that's awesome. He's a nice guy. I think I spoke with him on the phone one time as well. We had a long discussion. So I hope he's doing well. Hope he's feeling better. He's a nice guy. And then we have a question here from Suzette Laws, still waiting to hear your expertise. Yeah, that's another person that I want to speak with. I'm going to try to give her a call today, in fact. And Ricky Harris says, awesome as usual. So I thank everyone. And then the next person, the Butt Naked Podcast, he says, I was hit by an Amazon van driven by a third-party logistics company that is part of Amazon's delivery program. How can I show that Amazon is negligent? Well, I think that, if you're hit by an Amazon van and it's driven by the logistics company that's part of their delivery program, then I think that Amazon is at fault as well. So what you do is when you file the lawsuit or when your attorney writes up the lawsuit, what you want to do is you want to sue Amazon, you want to sue their delivery program, and you want to sue the owner of the vehicle. You do a search by the license plate, you find out who owns the vehicle, the registered owner. And you want to sue anybody that's part of Amazon, any type of entity, because Amazon has a lot of different entities. They're a huge company, right? So you want to sue anyone that has what's known as vicarious liability. And what that means is if Amazon has this delivery program, obviously it's part of Amazon, but it might also be part of like Amazon Logistics Delivery Systems, Inc. And then that's the company that runs the delivery program. And then vicarious liability means that they are liable for all their employees. So if the person driving it is either an employee or an agent of Amazon, then the parent company, Amazon, is liable for whatever their workers do as long as it's in the course and scope of their employment. Basically means doing their job, which they are doing, right? They're doing their job. They're delivering products for Amazon. So you're good. It's a good case. I would just sue everyone involved, and I believe both of them will be liable. Okay, let's go to the next question. It's from Laura Best. She says, what if the insurance of the other party accepts liability right away? What happens then? Well, nothing really happens. If they accept liability, it just means that you don't have to prove liability. They either give you an acceptance, like a letter saying we take liability. You could also file a motion in court and have the judge give you liability. And it doesn't really mean the case will settle. It could mean that it's more likely to settle, right? Because now they've accepted fault. They've taken fault. So now the only question remains, how much is fair to compensate you for all of your damages? Your lost wages, your future medical bills, your future medical expenses, your pain and suffering, your loss of enjoyment of life. That is the big, contentious issue. You might think, hey, I'm entitled to $1 million. They might say, you know what, I'll give you 10,000. So you still have a big fight. Just because they accepted liability doesn't mean the case is over. So like I said here in the comment, I said liability is only half the battle. What they really have to do is they have to pay you fair and reasonable compensation. And so, if they're willing to do that, if you're happy with the offer, if your attorney tells you that I believe this offer is fair, this offer is reasonable, then you can maybe take it. You could go to a mediation. You could negotiate it, get it up as high as possible. If you're happy with the number, you can accept it. If you're not happy with the number, if you feel like it's that example where you want $1 million and they're giving you like 10,000, well, then you have to go to trial and you have to prepare for trial on damages. So what you have to do there is you have to get your community witnesses, your friends, people that know you, your neighbors, your coworkers, that could talk about how you were before this injury and how you are after this injury, how your life has changed, right? So you want to show that human story. That's really important. And then the other thing is, of course, you got to line up all your doctors, all your medical records, and just present the case and then see what the jury will give you at trial. So that's what you have to do if you can't come to an agreement as to the amount with them. Okay, the next question is from Kia Garner. And she says, quick question, just came around your videos. When you sue someone for personal injury, for the actual injury, the insurance pays. But when it comes to emotional distress, do they pay that as well? Or do they come out their pocket? Because I know some torts in New York State apparently don't hold insurance companies for emotional distress. Sorry, just asking, as I have a personal injury, but it's tort and no one will take my case. So I'm trying to represent myself civilly in court. Wow, that's tough. So she's trying to represent herself. So that's known as pro se. Yeah, so feel free to text me. I'm happy to just do a consult. Maybe I could give you some advice. Maybe we could even help you. It's 347-566-9595. And with respect to your question, I mean, you could sue for emotional distress. Usually, as long as there's a tort, meaning it's a personal injury of some sort, as long as you have a physical injury, you could usually also sue for emotional distress, also known as mental anguish. Now, what you usually need in New York is you do need some kind of treatment with either a psychologist, psychiatrist, or some kind of, treatment to show that you really have this emotional distress. Just saying I'm emotionally distressed is not enough, right? You have to have the medical evidence. And it usually has to be in conjunction with a physical injury. So say it was a car crash and you have a bulging disc, right? But you haven't had any surgery, but then you also have this emotional distress that you're now afraid to get into a car. If you're just generally afraid to get into a car, afraid to drive, afraid to be a passenger in a car, and you don't see any providers, right, any doctors or specialists, it's going to be really hard. The judge could just dismiss your case. But if you see a psychologist, maybe even just once a month, once in a while, and you have these records, hey, this patient comes in, she says she's afraid to get into a car, now you have it documented. Now the psychologist can come to court and testify. Now you can sue for emotional distress as well as the physical injury. You could sue for both. So yeah, you could definitely do that, but feel free to reach out. I'd be happy to help. And let's see what other questions we have here. We have a question. Here's a question from the question at 28 minutes that I asked about it. I do have a neurologist, a concussion doctor. I'm doing oxygen therapy and I need to get a psychological test. I'm a truck driver and even my dispatch notices I forget a lot, and my girlfriend definitely knows because I forget conversations minutes later. Definitely frustrated, especially with double vision due to semi hitting me head on. Wow, so that's a serious case. I'm really sorry to hear that. That's terrible. That could be that probably sounds like a traumatic brain injury. So what you want to do there is get the right treatment, and you want to get, I think he's commenting on a video, another Last Week Tonight video where we answered some questions. I don't know exactly at the 28-minute mark. I don't remember what that was, but I mean, in general, just text me, 347-566-9595. I speak to a lot of people every week. I'm happy to speak with you, give you a free consultation. If we could help you, we'll help you. If you're happy with your current representation, that's great. We could just, give you a little bit of a second opinion or just give you a little bit of a consultation, whatever you need. We're trying to help the client. It's all about the client. It's not really about us or us trying to make money. We're doing okay as it is. We have enough business. We're busy enough, so we don't really need to, to get more cases just for that. So we want to just try to help people. So I think with this kind of case, what I would recommend is, have a good neurologist, somebody who's familiar with traumatic brain injury, so that neurologist could then refer you to a neuroradiologist. That radiologist can then do testing, like there's diffuse tensor imaging, there's arterial spin labeling, there is, SWI, there's a lot of different, there's PET scans, color imaging, there's a lot of different tests that they could do depending on your symptoms. And then you also may want to see a neuropsychologist. So those are usually the three types of doctors that you need. But I could do a little bit of a deeper dive. I need to know where this happened, how long has it been going on, how much coverage there is from the truck, questions like that. So I'm happy to do that consultation with you. Okay, the next question is from Dex Grady. He says, my lawyer screwed me and convinced me to take $309,000. And of course, they got 1/3 of it. Now I live with pain and have to walk through pain daily. Yeah, I mean, I'm sorry to hear that. I mean, 300,000 is not it's not a horrible amount. It's a pretty good amount. I don't know what the policy was. I mean, of course, if there was more, right? If he could have gotten 30 million, or if there was a crazy case worth a lot more, even 3 million, then it's a really bad number. But if the policy was, for example, 500,000 and there were some issues in the case, then maybe 300 is not so bad. So it really, again, depends on the circumstances. But he says, I think that's what I said. I said basically a fearless trial lawyer can turn 300,000 into 3 million or more as long as the case is strong. So sometimes, what I see is that lawyers just don't want to go to trial. They just are afraid, or they think that, either because they could lose, or because they just, for whatever reason, they just don't want to go to trial. They want to take the money. It's easy, right? Because when you have big money like that, 309,000 on the table, then you think well, if I say no to that money, then I go to trial. The trial could take 2 or 3 weeks of my time. Then I'm going to lose new clients. I'm not going to be able to run my office, and then who knows what happens at the end of that trial? I could lose, right? I could get 100,000. Then I spent all that time, all that uncertainty, all that stress, and then I just lost all this money, right? Because I got 100,000, but I could have had 300 before. And what if I get 0, right? Who knows? So because of all these uncertainties, lawyers are sometimes afraid to go to trial. So it's important to get a trial lawyer, somebody who has experience going to trial, somebody who has good results going to trial, because those are the people that are going to be able to get you more than the insurance company offer. Okay, the next question is from $1 Million Dave, or Dav. And he or she asks, me and my girlfriend and son were hit by someone running a red light. They had the minimum liability in California. They admitted, we got an attorney about 2 months later. My girlfriend was hurt. She hurt her back and ankle, and my hand and back and neck was hurt. We got MRIs and are going to start physical and occupational therapy. Do you think we will get a settlement? California liability is $15,000 per person and $30,000 per accident. Yeah, so I think you should get a settlement. It's a small policy, unfortunately. $15,000 means, per person means one of the people or any of the people involved in the crash. The most that any one person can get is $15,000, and $30,000 for the accident means that's how much they have, for the whole accident, for everybody involved in the accident. So, yeah, I mean, if you have 2 people, it sounds like it's him and his girlfriend, and son, so you have 3 people. So yeah, I mean, all they have for the whole accident is $30,000. So you have to split $30,000 between the 3 of you. So that's not so good. But if you send them a bad faith letter, right, and you tell them, hey, I want you to tender the $30,000. Here are my medical records. I believe it justifies it. You have 30 days. If they don't do it, as long as the letter is drafted correctly by a lawyer in California who's familiar with bad faith law, what'll happen is you can open the policy, then you can get more. So yeah, so that's something you might want to consider to speak to your lawyer about. or if you don't have a lawyer, just reach out to me. Okay, let's go to the next question. Oh, this question is from somebody. Oh, this question is all in Spanish. Oh, wow. Yeah, I don't think I could read this one. My Spanish from high school is a little bit, but not good enough to translate this long question. So, but I think I did translate it in Google Translate, and I commented to them, and they commented back. So I also invite the person to text me, call my office. I have Spanish-speaking attorneys in my office, and I have Spanish-speaking paralegals. So if you need somebody, you can just speak with them, and I'd be happy to help as well. Okay, Hector Soto asks, I went to a neurologist. He recommended I get an MRI, and he said my optic nerve might be damaged because one of the pupils on my eye is way bigger than the other, but I haven't had the MRI or anything. I'm still waiting. Yeah, definitely get that checked out. I mean, an optic nerve injury is very, very serious. I remember back when I first started my practice, I had this medical malpractice case where a boy went to a doctor complaining of, pain and trouble seeing. And the doctor thought, you know what, you just probably watched too much TV. This was maybe like 1999 when I first started my practice. So it turned out that he had this optic nerve pressure, something in his head was pressing on the optic nerve. And even though the delay from the doctor making that mistake of saying, hey, you just watched too much TV, and not finding that the optic nerve was being compressed until he went blind, it was only like 3 or 4 months. But we had an expert to say that if she would have diagnosed it timely, then he could have prevented the blindness. And this boy became blind at age 12 for the rest of his life. So that case settled for a few $1 million. And that was really early on in my career. I think I just became an attorney. This was like 1999. And I worked on it with a senior lawyer, with somebody with more experience. We teamed on it together, and we got a good result. And we had an infant compromise order. But yeah, to answer your question, you should definitely get that checked out. Make sure you see the right neuro-ophthalmologist, neurologist. Make sure you get it treated. And if you have any questions, just text me. I'm happy to talk to you about the legal aspect of your case. Or if it's in New York, I could recommend some doctors as well. I know a lot of the excellent doctors here. Okay, let me see. Let's do maybe like 1 or 2 more questions. We got Jason. He says, almost 3 years ago, I was sitting at a red light and a commercial flatbed hit the driver behind me and then hit me, totaled both cars. I'm 42 years old. They have 1 million with a 2 million umbrella. I've gone through physical therapy, injections in the neck and back, microdiscectomy, more physical therapy, radio frequency ablation, and still have lower back pain. Bulging disc and multiple valves in my neck and back. Liability was determined by the driver, or admired. He said admired, but I think he means admitted. Admitted by the driver. I used to be very active, but not anymore due to managing my pain. My trial is scheduled for April. They first offered $50K, and during mediation, upped it to $220K, but didn't accept. What do you think? This is in Florida. Yeah, I mean, I'm really sorry you're going through that. That sounds terrible. I mean, the fact that they have $3 million in coverage, he's 42 years old, commercial flatbed, seems like really they admitted liability, so that's not an issue, just like the other question, right? So that's not, so the only question is his damages. What is this worth? Well, physical therapy, injections, he's had a microdiscectomy. Yeah, I mean, I think in New York, something like that is usually worth anywhere from $300,000 all the way up to like maybe over $500,000, maybe into the $500,000, $600,000, $700,000. So if they're offering him $220, it sounds like he could probably get more than that. He probably can get $500 or more. I'm not really familiar with, Florida. It depends on where in Florida and everything. But you'll speak to your lawyer. If you need a second opinion, just let me know. Happy to get you a consult. But it sounds like you could get a good number. I mean, 220 is already better than 50. So already they're seeing the value in it. You see how these insurance companies work? They start off cheap. They try to protect their money. They try to save their money and pay you, the injured person, as little as possible. Like, we'll pay you 50. Will you take 50? No, will you take 60? See, and now they're being a little more reasonable, 220, but I don't think that's the ceiling. I think you can get more. So just max it out and either settle it, or if you have to, as long as your lawyer is ready and your lawyer is confident, maybe you could take it to trial. Okay, let me see here. Let's do a few, maybe 1 or 2 more questions. This one I think we answered already. What else do we have? Oh, here's a question from Isabel Duran, and I think it's a she, asks, so thanks so much for your vital and excellent info. 3 questions for you. Number 1, what if I don't want any surgeries, nor any type of injections, as I prefer the natural route? 2, how much of the settlement money does the victim get in the percentage? And 3, who pays for injuries and hospital bills? So yeah, I mean, if you don't want surgery or injections, that's fine. If you do the natural route, it just means that you could still receive a settlement. You have an injury and you've gotten treatment. That's known as conservative treatment, right? Or some people call it soft tissue, meaning that, like, for example, you got into a car crash, you go to the chiropractor, you go to the physical therapy doctor, you might even see a specialist, like an orthopedic or neurological specialist, but you just don't do anything, right? You don't want any injections, you don't want any surgeries, you want to do the natural route. Maybe you want to do yoga or stretching or physical therapy or exercise or whatever, drinking juices. You don't want anything like that. Now look, if the doctor thinks that you have a herniated disc and you need like a fusion and now you don't do it, then the insurance company could argue, well, you failed to mitigate your damages, meaning you could have lessened or mitigated your injuries by doing the surgery, which your own doctor thinks you need, right? And the fact that you haven't done it means that you're going to get less money. We don't have to pay you because you failed to mitigate your damages. Also, if you were to do the surgery, let's say like a fusion, well, now that's a serious procedure. So you have more damages, more medical evidence, and you're going to get more money. If you don't do anything, you're probably going to get a lot less money, but that's a decision you have to make with yourself, really. What do you need? What do you prefer? And then what your doctors think, right? You can get a second opinion, just like you can get a second opinion from me as a lawyer. You can get a second opinion from doctors. If one doctor says do surgery, but you don't agree, go to another doctor. He might be able to, or she might be able to heal you naturally. It's better, right? Nobody wants a cage in their spine if they don't need one. So of course, do that. But in terms of the percentage, the second part, how much of the settlement money does the victim get? They usually get about 2/3. So the legal fee is usually 33%. Some states it's 40%, but for the most part, here in New York, it's 33%. And then the third question, who pays for the injuries and medical bills? Well, the medical bills, it depends also on which state you're in. Here in New York, the way it works is for a car crash case, for example, we have a separate policy for no fault, right? So that's a personal injury protection. So the car that you're sitting in pays for all your medical bills up to $50,000. It's like health insurance. So you have that, plus in addition to that, you could sue the defendant, right? The person who hit you in the rear. So you can get the health insurance, the no fault, $50,000. That doesn't go to you, right? That goes to doctors, hospitals, nurses, medical providers, physical therapists, whoever gives you medical care, right? So that goes to other people to give you treatment. And then those other people get paid. So you don't have to pay those medical bills up to $50,000. Now, you could buy, excess no fault, and then sometimes it's not 50, it's like 75 or it's even 100. Not a lot of people buy that. A lot of the insurance brokers don't explain that. So, but sometimes people can buy that. You can buy that on your policy here in New York. So anyway, so that's your health insurance component, right? But then you also have the one where you sue the defendant, and then whatever that defendant has. Sometimes they have 25,000, sometimes they have $1 million or more. So, and then that's your bodily injury, that's your pain and suffering, loss of enjoyment of life. That's the personal injury settlement that you get, is the bodily injury. Now, if it's like a slip and fall, then it's a little different, right? Because then there's no fault. It's just you use your health insurance, or if you don't have health insurance, you can do what's known as a letter of protection or a lien. What that basically means is the doctor will treat you for free now, but then when your case settles, let's say you get $100,000 on your case, the doctor might say, well, I gave you 3 months of treatment, so my bill is $10,000. So you have to pay the doctor back out of your settlement because there's no other method of payment. So usually it's one of those. It's usually primary, meaning workers' comp or no fault, or health insurance, or it's this lien, which means that at the end of the case, the doctor gets like a piece of the pie because they're giving you all the treatment up front for free. And then when you get your big check settlement, you have to pay back the doctor because he's got that, he's protected by that letter that you signed to get him paid or her paid for the treatment that they do. So I hope this was helpful. Okay, thank you everyone. Thank you for watching our channel. And I think we're gonna start out with some more questions in the next video. And yeah, the next question I see here is about an Amazon hit and run. So maybe that'll be the next question that we answer in the next video. It's from Ms. Mills. So I'll make a note. That'll be the next one we start with. Thank you so much for watching our channel. Please like and subscribe to our channel. If you believe that we gave you any type of helpful content, you could thank us within YouTube. You could also click a link to write us a review. That's just really helpful because then people will know about our firm, and we have offices in the Bronx, Brooklyn, Queens. And then if you have any kind of interaction with us or we gave you a consultation, you could write us a review and show your appreciation. And then that will let everyone else know about our firm. And maybe, more people will contact us. We'll be more prominent in the, in our listings for our firm, which is something we're striving to do. And then also, if you want a consultation, we have a link that you could fill out, and then it just has basic information like your name, what happened, and then your injury information. And once we have that, then we could give you a little bit of an assessment, call you back, schedule a consult, and then help you personally. That's one of the ways to reach us. It's probably even better than just texting me, because that kind of gives me all the information that I need to then text you or reach out to you and schedule something. So it's a perfect way to reach out. Okay, everyone, thank you so much. Have a great weekend. Happy holidays, and we will talk to you very soon. Okay, bye-bye.